Yeah.
My lord, I'm moving on to the res inter alios acta point, which is at paragraph 18 and following of the supplementary skeleton. And those other submissions I would, even though this is not in yet, I won't read it out to just put it in the transcript. But the first question is, what is it that I say is not res inter alios acta, but that the judge found, or my learned friend submits, was in res inter alios acta? And my submission is that is a gain by the avoidance of an external book hedge for the net risk in the same amount on...
So a gain from a...
The gain from the avoidance of an external book hedge for the same amount and on materially the same terms as the internal hedge, represented at page 32, but looked at from the point of view of 101, the seller. So it is that which I say is not res inter alios acta. And our submissions start with the test, and essentially...
I'm sorry to hold you up so soon.
No. I want to ask the right question.
I understood the submission all the way up to, but looked at from the point of view of 101 as the seller. If we're looking at an avoided book hedge,
VITOL, as fronted for by 101, would have made the same. When I say seller, it was just because it was in the sell column. 101, VITOL, as represented or fronted by 101, would have made the same contract with an external party as it did with 645, or notionally with 645, as represented by those three entries in those three roles. It was selling. Your lordship put it to me that they were.
It's VITOL rather than 101, but I understand.
Yes.
Why you put it.
Well, I say VITOL fronted by 101 because 101 was the people they put on the front, and it's a book hedge, and it's for the net exposure, which is represented by the quantities there in the hedge, and so as a matter of law, I don't think there's much to say here. The test is as set out in both my learned friend's skeleton and in the judgment based on Swinson at 154. I won't take you to it, but it's essentially causation. Was the benefit that I just described, i.e. the avoidance of the loss, proximately caused by my client's breach? And there is a wrinkle in Swinson because his lordship there said, such as when he mitigates the loss or avoids the loss from his own resources, such as paying insurance premium or his own work. And so that is a particular instance of a non-caused benefit. And that qualification or exception is obviously designed to take account of the insurance position, whereby you could say that the insurance contract reduces the victim's loss, the plaintiff's loss, but as a matter of policy, the court has said that is not caused by the breach, but it's a result of your own prudence in paying premiums. And similar principles apply in respect of social security and charitable donations. But that is a slight exception from the causation or a qualification on the causation aspect, and it's expressed in terms of where the gain is attributable to his premiums, his contributions, or his work. The exact quote, that's in paragraph 18. And in my submission, that doesn't apply. That the hedging is caused by a breach in the oil trading or carriage of oil context, because, as the judge found in his common ground, hedging is inevitable. And once hedging is inevitable, then it doesn't matter what the precise concatenation of circumstances is that produces the hedging gain. In principle, it is caused...
What hedging is it inevitable? I haven't got in mind the passage you've got, you're serving the judgment.
Yes.
Hedging by 645 is inevitable.
No,
hedging of its book by VITOL is inevitable. Hedging
generally of price risks is inevitable. Let me it's paragraph 148 of the judgment. I think the answer to your lordship's question is that the author there and the judge there at 148 and I in my submission is not distinguishing between different types of hedging, but that hedging generally is inevitable. Paragraph 148 at page 89 of the bundle.
Well, that's just citing the passage from Claimant.
Yes, but he then went on to cite Mr. Justice Christopher Clark, and his word was companies such as Shaw habitually hedge.
That's rather different.
And that was a trader.
Habitually hedging is not the same as inevitably hedging.
Well, I obviously go for inevitable, but habitually.
But I understood your submission to be, when you said inevitable, i.e., there's never any risk of running unexpectedly. Isn't the evidence generally about?
Your lordship is right, and so the inevitable needs to be qualified by.
I mean, habitual. If you common.
I will live with habitual. Alternatively, inevitable, unless you're a speculator. So it comes to the same thing. Yes, but okay. So I've quoted the book which the judge quoted, and I mean. The finding on this is at 155, after quoting Swinson for the general test, which is what I just referred to but not read. And he says an external hedge are to be taken into account in reduction of loss, para 155. The benefit received as a result of such a hedge would not be one that rose independently of the circumstances giving rise to the loss, and this reflects the decisions in Glencore and Choyle, and if it is loss-making, then he can recover it. And our submission is that there is no material difference between the gain on an external hedge and a gain by avoiding a losing external hedge. No difference in principle. And we also say that hedging is habitual, and the Glencore risk management, the VITOL risk management system of Vista was perfectly usual, as was described by the judge. So, as a consequence of the rise in the market and the perfectly usual risk management system of VITOL, which used hedging, this gain was caused in my submission. And it doesn't matter that it was the avoidance of a losing external hedge as opposed to a winning external hedge. That is that's a mere detail or concatenation, which doesn't affect the causation issue, and obviously no remoteness issues arise. So
it's a little bit broad to say the general principle of causation. I mean, the exceptions rather, what you call the exceptions, it isn't really a principle of causation, or you get into all sorts of complicated things. What sort of causation, but for causation, Lord Sumption refers to something being occasioned by the loss, but there's no causal relationship. I'm a bit uneasy about saying that the central principle is causation. It's something more subtle and difficult to define than that. It's almost more like remoteness.
Well,
he says it's difficult to identify a single principle underlying every case.
But then he says, is your lordship reading it, paragraph 154?
Well, I'm reading from 154.
Yes,
that
me
happens
too.
to be.
So the general rule is that the loss which has been avoided is not recoverable. There's an exception for collateral payments, res inter alios acta, where the law treats as not making good.
Well, an exception. Oh, I see. Yes, straight up. carry on.
And what that must mean is that but-for causation is taken as granted. If there's no but-for causation, we're not even in the game. So he must there mean proximate causation. There's an exception for collateral.
Yeah, but it's the proximate that does all the work.
It does. It always does. But nevertheless, that's the test. Because he says, difficult to underlie this single principle. The critical factor is not the source of the benefit, but its character. Collateral benefits are those whose receipt arose independently. Thus, a gift received by the claimant, even if occasioned by the loss, is regarded as independent because its gratuitous character means there is no causal relationship. Now, once again, he must there mean proximate causation.
Yes, well, I see that, but what I'm just suggesting is that actually it's not the most illuminating label for the underlying principle to say it's about causation.
Yeah.
And I don't think that's quite what Lord Sumption says. Anyway, there it is.
Yes. Well, my submission of what he says is it's causation, it's proximate causation, but there is the particular aspect that things which can be said to be attributable to your premium's contribution or work are regarded as on the not proximately caused side of the line.
Well, I have a lot of difficulty with that, not least because of the Globalia case, which I was involved in, first instance, in which I sought to identify a series of principles about links and causation and so on. And one of those principles was you had to show direct causative link between breach and benefit. You couldn't do it in 2 stages, and there were certain types of benefit that fell outside the scope of that, not merely the own funds, but in that case, because it was a type of loss which wasn't legally caused by the breach, it was the ship owner's decision in relation to sale of the ship. Although as a matter of factual causation, there was no difficulty in following it through. Now that was, the Supreme Court heard the appeal in that case at the same time as Swinson. And then the Swinson judgment came out first, and then Lord Clark gave the unanimous view of it in my case. They didn't specifically endorse the principles that I set out, but they did simply recite them and say that I got the answer right. So I'm not suggesting it's necessarily an adoption of the principles I set out, but it certainly is an example of a case where what you're describing wouldn't have explained the result.
Yes.
So all I'm saying is that I agree with what my Lord put you.
Yes. Okay.
You may be oversimplifying that.
Yes. Well, I suppose I'm submitting that what Lord Sumption meant. What the general rule is: loss which has been avoided is not recoverable. Now that must mean loss, and in the case of benefit, which was caused. So a benefit reducing the loss avoids the loss, but there must be a causation at that level.
Yeah, I mean, the causation in some form is a sine qua non.
Yes. And then there's an exception for collateral benefits, and then he describes that as no causal relationship. So,
Yes, I hesitate to say this about Lord Sumption, but lots of lawyers seem to have a very broad view of how useful it is to talk about cause outside the context of but-for causation.
Yes.
And very often it's not actually helpful.
Yes. Okay, well, my submission, I've established but-for causation, if you're with me on the whole of everything else, and therefore there then has to be an exception proved, which is labelled res inter alios acta, and the burden of the exception that has to be proved against me is to negate, in the words, means that there's no causal relation between them. And so my rationalization of this judgment, without having delved into it, the Court of Appeal or the Gavalia case, is that if you prove but-for causation, prima facie the benefit reduces the loss. But by way of exception to that, called res inter alios acta, it is open to the plaintiff, my learned friend Mr. Tom's in this situation, to establish no causal relation and independence to some aspects of which are, and that is often done in cases of own resources. That's my submission about what to derive from this. And the proximate causation is not negated, I would submit, if this is what my Lord Popplewell was suggesting, is not negated by the fact that there are two stages, or can be analysed to be two stages. It's just direct cause as it is in the rest of, proximate cause as in the rest of the law. So, for example, take the case of a row of stationary cars at a red light, and somebody piles into the last car. He's definitely caused the damage to that car, but that car piles into the one in front. There are two stages there, but the damage to the second car is definitely directly caused by the wrong.
Maybe in your car example, but there are a number of authorities which support, or at least when I gave my judgment, I thought supported the proposition. I think Hussey and Eales was one of them. It isn't sufficient to do it in two stages, from breach to causing the mitigation, and mitigation to causing the benefit.
But
anyway,
we
haven't got that here. And
we haven't got that here. In my submission,
not really prepared to address it.
In my submission, the rolling exercise is just one stage. The rolling exercise involved making that swap internally and not making the external swap that would have otherwise followed. In my submission, that's one stage. That's proximate, that's but-for causation, that, if you're with me on the facts, obviously, that's but-for causation, that's proximate causation, and that's not own resources, and therefore resident.
Well, we see that.
And I think there's just, I've exceeded my 20 minutes, there's just one authority I should show you, which is Barnett, which is tab 7 of the authorities bundle. My learned friend has relied on for slightly different, but I think it's fair to work this out. That was a case where the bank had the right of indemnity in the case of loss caused by closing out of a funding transaction. And the bank lost, and the ratio was that there wasn't a funding transaction. It was a transaction, but it wasn't a funding transaction. But his lordship also considered the question of loss, and the argument in court was that loss had been caused because the internal swap, which did not itself cause a loss, had a knock-on effect on the external position of the bank. And in that case, the bank was found to have what's called a hedging flat policy, which is it hedged all its risks back to flatness. So the internal swap was accepted, and this is the point my learned friend relies on. It was accepted that the internal swap, being purely internal between the Treasury Department and the corporate department of the bank, did not of itself cause a loss. But there was an argument that it had an effect, the preciseness of which we don't need to go into on the external swap. Having, as a matter of ratio, decided that the indemnity clause didn't apply because if there was a loss, it wasn't on a funding transaction, because the transaction in question wasn't funding. At paragraph 54 within tab 7, Mr. Justice Warren said that the construction, having talked about the possible external hedges, he says the construction is not displaced by any of the factors on which Mr. John relies, and we can go 4 lines down. He says the point only arises, of course, if the internal swap is contrary to my conclusion of funding transaction. So what follows is obiter, because he held it wasn't. If that is wrong, however, it is nonetheless clearly correct to say that the internal swap, viewed on its own, gave rise to no loss or cost. Indeed, Mr. John accepts that proposition, as I recorded in paragraph 36 above. As to her submission that the internal swap does give rise to a loss and a cost because of the winding up of the external hedge in consequence, I disagree. The internal swap does not give rise, and I think that comma's stray, does not give rise to any loss or cost to the bank, even though the external hedge may only have been entered into because of the internal swap. And so he seems to be making a decision that any loss on winding up an external swap is not caused by an internal swap, even though the original entry into the external swap was only entered into because of the internal swap. So I suppose, my learned friend may say that's a case that shows that there's a break in the chain of causation between an act or event which leads to an internal swap, which avoids an external swap. But in my submission, it's a case on a different issue, which was construing loss in a policy, and it doesn't purport to lay down any principle, any one-stage or two-stage principle, and if it does, there is no reasoning in support of that decision, and it's not ultimately of any assistance to this court in deciding the question, which I go back to submitting is a question of if I prove but-for causation, which I think I have, my friend establishing that the chain of causation in terms of proximate causation is broken because of something that happened in the case. And the mere fact that, although it was all one transaction, my chain of causation is, as it were, within one breath at the same time, do an internal swap instead of an external swap doesn't bring it within this sort of reasoning, which is a question of fact anyway. So I think that's what I've got to say. I invite you to give permission as on the application that we've done to the extent necessary, and in any event, I invite you to allow the appeal.
Thank you very much, Mr. Barry. Yes, Mr. Toms.
My Lords, the approach I'm going to take to my submissions is firstly just make a series of short submissions in respect of what the VISTA system is and what the court found about it. I'm then going to very briefly explain the basis upon which the case was actually argued at trial, because, as you may have realised, you've had no arguments at all in support of the case that was run at trial has been determined incorrectly. The arguments you've had today have been purely directed at the new case concerning the avoidance of the external bookage. So, having shown you what was argued at trial, I'll then jump to make my submissions on.
I'm sorry, before you get into your substance, there's one thing I just meant to mention briefly on a purely housekeeping point when we came back. I said something which I think may have been taken as a suggestion that a simple way of getting a transcript, if this appealed to those doing so, was simply to watch the live stream and do it from that. I think there may be questions as to whether that is permissible. It may not be an entirely straightforward question. And can I therefore ask that if, as you've kindly offered, there is to be a transcript, it be bespoken from the through the internal system of the law courts in the usual way. It'll probably be just as efficient and just as cheap, but I think that's the pucker way of doing it.
I think all I can warrant is that we will use our best endeavours to that effect. But
yes, but I just didn't want there to be some confusion because I may have incautiously suggested something that isn't the right way of doing it. Okay.
I'm obliged. So VISTA, what is VISTA? The judgment makes clear in the very careful statements in paragraphs 42 to 66 and 134 to 144 that VISTA is a system to enable VITOL to understand its overall net exposure across its entire book of trades, and in the light of that understanding, to decide whether external action should be taken in the form of the conclusion of external hedges with third parties in respect of that net exposure, or if such action was not taken, to do what has been referred to as speculation, namely to retain that overall net risk. And of course, as a matter of common sense, there could be somewhere between the two, where only some of the net exposure was laid off and the rest retained. It would not be all or nothing. Contrary to what Mr. Berry said towards the end of his submissions this morning, there was no dispute at trial that pricing risks of the kind with which we were concerned at trial, namely the pricing risk derived from the TOTSA contract, might have been speculated on. And if we could please turn up the judgment in the core bundle tab 8 at page 88. Paragraph 142. So here, the judge, it's important to understand, is dealing with a different risk than the one with which you have been concerned today. It's to deal with the risk derived from the TOTSA contract. And it said, in respect of that, there may or may not have been further internal transactions. However, the parties agreed that there were ultimately three possibilities as to how that risk could have ended up being dealt with. First, the risk may have been offset by one or more other transactions within the VISTA system. Second, there may have been a decision to seek an external hedge based on the net risk ultimately remaining after internal offsetting. Or third, there could have been a decision which probably would have needed to be specifically authorised to run a speculative position on the net risk remaining. So at trial, it was agreed between the parties that it was possible, that the type of risk with which we are concerned today could have been speculated upon. And indeed, at 143, the case was opened on that basis. Mr. Young's point being that if there had been a positive decision to speculate in respect of that risk, and I should emphasise it's a different risk than the one that we're concerned with today, there would have been evidence from VITOL about that, which there was not. So, no distinction being drawn between the types of contracts that can give rise to speculation. The very type of risk with which we are concerned today is one which was common ground between the parties, could have been speculated upon. To understand its net exposure, VITOL would, in respect of all of its physical trades, automatically input into VISTA an internal paper swap on identical terms.
So are you reading from somewhere?
I'm just reading from my notes. Sorry.
I'm sorry.
I keep my eyes.
It sounded so authoritative. I thought it must be from the judgment. Yes.
So this is just my identification of some of the key parts, because in some respects, certain glosses have been made. So what VITOL do is they put all of their physical trades into VISTA, and then they automatically input an internal paper swap on identical terms that would apply if the individual pricing risk associated with the physical trade had been externally hedged. And then having done that, and this came out from an exchange with my Lord Justice Popplewell and Mr. Berry, they would then subsequently handle them just as if they were externally hedged. And that is why the rolling occurred. It was simply an application of VITOL's practice. The booking of those swaps was not the consequence of an exercise of discretion by a commercial analyst, but rather the invariable practice as a necessary part of seeking to establish its net exposure. The reason that was done was to create a proxy for the pricing risk associated with the actual physical trade, and as the first step in establishing the net exposure.
So, in other words, effectively to keep the swap entered into as part of the ordinary policy at the start, to keep it up to date.
Yes.
Yes.
But first of all, you turn it into a paper risk, which reflects the actual risk on the underlying trade, and then the practice is to run it as if it was an external hedge, so that if there are any delays or any effects on the actual physical trade, one would be aware of what that effect was on the net exposure. So whereas here we have a purchase by 645 of swaps in respect of the pricing risk associated with the physical trade with TOTSA, the sale side of that is automatically generated elsewhere in VISTA on equal and opposite terms. There is no negotiation for that swap, whether between traders or otherwise. Rather, the sale side is automatically generated as a means of reflecting the pricing risk originating with the TOTSA trade. So there is at this stage no suggestion of anyone turning their mind whether to accept the swap. Language of that kind being used by Mr. Berry both in his written and oral submissions. Not so, the opposite side is simply automatically allocated within VISTA. And what that means is that VITOL was both the buyer and the seller of each and every internal swap. Now, the buy side stayed within 645. The sell side was, in this case, put into a group of portfolios, sorry, a group or portfolio of other paper transactions recorded in Vista. That was 101. And within that group of trades, there was already a series of unconnected paper risks derived from physical trades, having been put there because the same process applied to its underlying physical trades. And that was simply a repository of paper risk derived from trading by VITOL. So that is the process. It starts at that level, and it's done for the purposes of establishing each risk with each trade to then establish, as I say, the net exposure. So the next stage, which is done on multiple levels, which is important to the new case that my learned friend seeks to advance, is that a commercial analyst may or would look for offsetting risks. And the evidence, and I'll show you this later on, the evidence will show that that's not done simply, for example, in 101, the portfolio in which the paper risk has been transferred into. It would be done in respect of other portfolios, if needed, in respect of other physical products, in respect of other geographical regions. Again, that process was not a process of negotiation where somebody had to agree to essentially offset its risk against another risk. It was performed by the commercial analysts, not traders, with a view to understanding, once again, the net risk exposure. So to the extent that my learned friend says in his supplemental, we don't need to turn it up at paragraph 7, that there was some process of offer and acceptance or negotiation at that stage, that's not right. Rather, the commercial analyst is simply reviewing the portfolios, trying to understand the net exposure, and as part of that, trying to see whether there are offsetting transactions. Those risks during that offsetting process could, in theory, be one-to-one. So a single paper risk derived from a single physical trade with an offsetting single paper risk from another single physical trade. But the judge held that that was unlikely to be the case. Rather, because there would not be expected to be equal and opposite physical trades concluded on the same day, on the same terms. What one would like you to have would be multiple paper swaps, potentially on both sides of the swap, and potentially with some, but not all of the pricing risk derived from an individual physical trade being used, along with pricing risks derived from other physical trades. So just to put that in slightly more simpler terms, offsetting would be done by bundling up risks taken from here, there, multiple different contracts, possibly leaving some of the pricing risk with an individual contract to be left with in a different offsetting arrangement. Because, of course, what you're looking for is pricing risks for the same pricing dates. That is what you would be looking at initially to match. And that process, as I say, would go not only in one portfolio, it would go dynamically across the book, the group, until a net pricing exposure across the book of trades was established. And if it were, that would be the product of that dynamic and complex process which I have just described, to which every physical trade on the books at the relevant time would have contributed. In no meaningful sense could it be said that the net exposure was referable to certain identifiable parts of the book. It was a product of them all. They were the recipe which together generated the net exposure. If we could now just please go to the supplemental bundle. I just wanted to show you something that we saw this morning in a slightly different context. If we could go to Mr. Smith's statement, page 11, paragraph 43.
Was it at that final stage split in relation to pricing risk separately for each individual input?
I think that the evidence at trial level didn't descend into that level of detail. And I'm going to come on to explain in a moment that this wasn't something that was of any great significance at trial. And I'll show you in a moment that the case wasn't even opened. on the basis that anything that happened after the swap had been booked was anyway relevant. That was developed through cross-examination. So the evidence on your particular question, my lord, was not it just wasn't there. But what I did want to show you, which was in the passage that we looked at from Mr. Smith this morning, page 11, paragraph 43, which my learned friend sought to rely upon, I think, to support the proposition that it was probable that if there was a non-offset risk, it would be externally hedged. Just wanted to bring out.
So where are we going?
Sorry, we're in paragraph 43 of Mr. Smith's statement at page 11. So in 43, he's summarising, in essence, what I just tried to give a little bit more detail to derive from the evidence which I've just findings. And he says the procedures involve pooling and offsetting risk from many different transactions in different groups and between different subdivisions of VITOL's business. Only after the net effect of this process has been considered would external hedges be entered into, and then only in respect of the net position of VITOL SA. So I just wanted to show you that to emphasise that he says, his evidence, only after the net effect of the process had been considered, i.e. once the pooling and offsetting risks from many different transactions in different groups and between different subdivisions had been completed, with the question of do we externally hedge or do we not arise. And just then dealing with the gloss that Mr. Berry tried to apply to what was said here by Mr. Smith, namely he was saying that they would probably hedge. If we could just remind ourselves, please, at page 6 in his statement of what he said at para 19. He said that if the corporate entity was long or short on a net basis, we may use external hedges. And I've already shown you that that was the case that was put at trial by Mr. Young on behalf of the appellant. So there's no warrant in here, even if it was appropriate to ignore what the judge held as to what was possible. There's no warrant for saying that Mr. Smith here was saying that it was probable that an external hedge would be concluded if there was a net exposure when the process, he explains, was concluded. So that is and was VISTA in its perhaps most basic form, but reflecting in our submission a significant degree of complexity, a large number of trades across a significant period. And when considering the evidence that Mr. Berry has relied upon today, and therefore considering the new case that he seeks to argue, it's important to remind ourselves of what in fact was being argued on his client's behalf at the trial, because it certainly was not what is being argued today. And what was being argued, in very general terms, was that the effect in the breach situation of the internal swaps booked in VISTA and then rolled was to avoid VITOL's loss on the TOTSA contract. And that was said to be because the purchase side of the swaps booked in 645 was profit making. And it was argued that the profit made by 645 could be taken to be profit made by VITOL by reference to the Bremer-Handels case, which the judge dealt with in his judgment. In other words, it was argued that you could ignore the loss booked in VISTA in 101 in the equal and opposite swap in the equal and opposite amount, and simply take the financial position of 645. So that was the case. The case was that the internal swap, in fact, increased VITOL's financial position in the breach world, nothing about the counterfactual world, in the breach world, by reason of the breach. That is not an argument that's advanced today. Unsurprisingly, the evidence and arguments at trial were directed to that question. In the breach world, what effect did the internal swap have? And indeed, as I've alluded to already, the case was opened on the basis that it was unnecessary to look beyond the profit booked against 645, and whatever may have subsequently happened internally within VITOL was irrelevant. Can I make good that submission, please, by showing you the judgment, page 95. 95 at para 175. And rather than reading that out, could I just invite your lordships just to read to yourself 175, perhaps the entirety of 175, please. So, just pausing there, the evidence that you have been shown is evidence which arose through cross-examination, which didn't go to the case as it opened, but to which we took no objection, because the fallacy underlying the claimant trial, which I'll come to, was the fallacy that 645 could be treated separately from 101. But when you come to Mr. Berry's arguments today, it's worthy of note that it was recognised that there may well have been additional documentation or evidence to be given about how the VISTA system had in fact operated in the breach world, but that had not been produced because of the way in which the appellant won its case. So the evidence that you heard was shown, earlier today about what might have happened to the risk with which this court was concerned, Justice Burt, Simon Burt sitting as a High Court judge, is different evidence than the evidence. Sorry, I'm going to start again. Sorry, I've lost my train. So going back to the case that was argued before the judge, that was rejected on the basis that since the profit made by 645 was pursuant to an internal swap, and there was an equal and opposite loss, there was no loss. There was no loss to VITOL. And you could not treat those two ID numbers as if they were separate legal identities. And he said if he was wrong about that, and this is where res inter alios acta arose before the judge, it was a different thing. The question was whether the gain, the source of the gain recorded against 645, if that could in fact change the financial position of VITOL, was that gain res inter alios acta? And the argument there was that if 645 could in any way have made a real financial gain by reason of the breach, the source of it must have been another physical trade within VITOL's book. And it was argued and accepted by the judge that if contrary to his primary findings, that there had been a gain, that it would have been res inter alios acta. So that was the case at trial. The judge decided the issues before him. There was no suggestion at trial that the entire breach and counterfactual financial position needed to be explored. The focus was purely on the effect of the swap in the breach world. And there was no suggestion, as Mr. Berry accepts, that in the counterfactual world, my client would have concluded a external hedge on on an unidentified date in respect of unidentified risks, which would have been loss-making in the amount of $2.8 million. And importantly, that hedge, let's be clear, is not said by Mr. Berry to be a hedge in respect of pricing risk derived from the TOTSA contract. It's said either to be an external book hedge, which we would understand to be an external hedge of the entire net exposure once the process that Mr. Smith explained had been completed. Or, if, contrary to the evidence that VITOL wouldn't do this, he were able to establish that only certain risks associated with certain transactions would have been externally hedged. The risks in question are said to be risks which in the breach world would have offset the pricing risk in the TOTSA contract by reason of delay. So the external hedge that he says has been avoided is not an external hedge in respect of the TOTSA contract. It's in respect of transactions which he says in the breach world would have offset the pricing risk associated with the rolling the swaps in respect of the TOTSA contract, but which in the counterfactual world would not have had those risks to offset against. And I'll come back to it later on, but his submission proceeds on the basis that in that counterfactual world there would have been no other transactions against which those risks could be offset internally. Because self-evidently, if there were, then there would have been no external hedge. We don't accept the characterization that Mr. Young at trial would have been able to turn around in closing and say, Mr. Burt, you should hold that VITOL have avoided the conclusion of a loss-making external hedge in the counterfactual world. It wouldn't have been open because that is a positive case which my client would have had to have noticed in advance of the trial. It would have had to have been supported by evidence directed to the specific point by Mr. Beckett, the appellant's expert, and it would have had to have been explored explicitly at trial. In other words, my witnesses would have had to be challenged and had put to them that what they in fact would have done in a counterfactual world was exactly that and precisely that. So, in a sense, it's neither here nor there what would have happened if Mr. Young had tried to raise it in the closing, but our clear position is that it wouldn't have been open to him to do it. It wouldn't have been open to him to open the case on that basis. He would have had to come to court with the evidence upon which he relied, and with my client having had an opportunity to respond to that positive case, made in effect as a defence to reduce the undisputed loss suffered on the physical contract by reason of the appellant's breach of charter party. So that was at the trial. And as I say, today you have heard no argument which supports the way in which that case was put at trial. You have had explanations for how the case that Mr. Berry now seeks to advance relates to that case. But his new case, let's be clear, proceeds on the basis that the judge was right in respect to the matters that he decided. Because if the internal swaps did in fact in the breach world increase my client's financial position, then the loss-making external hedge would have no effect on VITOL's net position. It would be the equal and opposite effect of the gain made by reason of the internal swaps. So let's be clear, the case that Mr. Berry seeks to argue not only was not run at trial, it was inconsistent with the case that was advanced at trial. Now, of course, that wouldn't have stopped it from being put as an alternative, but it's a striking feature that there's been no attempt today to defend the basis upon which the case was argued before Mr. Burt, and all you have heard is, in essence, arguments of fact. Here in the Court of Appeal, we have had over 2.5 hours of submission by reference to fact. So, In broad terms, where does that leave Mr. Berry? Well, the position is, we say, as follows. He accepts that the argument he now wishes to advance was not advanced at trial. He accepts that the argument is one of fact. He must accept that he does not have any direct factual findings that he can rely upon in the judgment. He did try, in answer to a question from my Lord Justice Popplewell, say that there was factual findings concerning whether or not VITOL would speculate. But as I've already shown you, the case was argued on the basis that they might well speculate with these types of risks. So that even if it was a factual finding, which it wasn't, it was a discussion by the judge about a piece of evidence. When one looks at the judgment in its entirety, the finding is that it is possible that there would have been speculation if, and I'll come back to that, there was an unoffset risk of the kind that he says. He showed you an excerpt in the transcript where something that could have been the beginning of this case was put to Mr. Smith. But of course, he can't put anything put to anyone about a counterfactual external hedge, because it just wasn't in the arena. And I'll develop this in due course, but it really does matter very much precisely what it is that it is said that would have been done. Because again, as my Lord Justice Popplewell observed, the price of a hedge depends upon when it is completed. And necessarily, it also depends upon what is being hedged. And as I'll develop, it's just a total matter of speculation by Mr. Berry as to what would have happened in the counterfactual. No attempt is made to justify or explain why the argument was not raised at trial. In a sense, that doesn't really matter. But what does matter is it plainly could have been. This could have been raised at trial. No doubt about it at all. The fact that it seems likely that Mr. Berry has thought of an argument that Mr. Young had not matters not. What matters is it could have been argued. So where are we? We're in a position where the court's been asked to make inferences from selected bits of transcript directed to different questions than that with which we're concerned today, with no real support from the judge who was making factual findings in respect of a different issue. But where should we be? I don't pose that rhetorically, but where we should be is that this matter wouldn't have come before this court without an investigation at trial, which would involve, amongst other things, total reconstruction in the counterfactual world of VISTA. What would have happened in VISTA if you took out paper risks derived from the breach? That would have had to have been investigated, would have to have been supported by disclosure, very careful analysis, none of which needed to be done and was done at trial. One would need to look at the overall position of VITOL in the factual and counterfactual world. You can't just look in isolation at different parts of their book and say, oh look, there's a difference. The loss would have been avoided. That's just, excuse the use of the word, that's just speculation on Mr. Berry's part. One simply does not know. And one doesn't even know, for example, whether any external hedges in respect of net exposure were in fact concluded in the factual world. That wasn't something that Mr. Burt, had to decide. All we know from the judgment is that there was no evidence of any external hedging in respect of the Geno pricing, the Topsy pricing. But there may have been other external hedges derived from the application of the VISTA process on the same day, which one would need to know about to compare the factual and counterfactual position of VITOL as a whole. So I'll develop the argument, but it's not open to a litigant to run a case on a factual basis at trial, fail, get permission from the judge based on the case that it ran at trial, even if objectively one can say now, oh, this argument does fall within the grounds of appeal. Plainly, Mr. Burt was not granting permission to run this argument because it wasn't an argument that he'd heard. And it's quite clear from his reasons that he made clear that Mr. Young was not challenging any of his factual findings. Perhaps I could just show you that in the reasons given. So that's tab 9 in the core bundle. Page 110. Dealing with ground 1, which is the ground.
So sorry, can you just give me the reference?
Sorry, it's the core, tab 9, page 110.
Thank you.
So I just wanted to point out that when dealing with ground 1, Mr. Burt was keen to make sure that Mr. Young wasn't seeking to appeal any finding of fact and recorded that in his reasons on ground 1. Now, I appreciate that what Mr. Berry is doing is not really trying to appeal any finding of facts, although he's shaving at the edges on a few. But what he is doing is explaining beyond what could have conceivably be contemplated by Mr. Burt in granting leave. So, and I'll show you the authorities in a moment, but we say really, once the court concludes that had this point, been ventilated properly in advance of trial, evidence other than that which is before the court today would have been available, then the court can't go near this appeal and submission, because any inference that you try to make based on selective, incomplete evidence is fraught with risk, and profoundly unfair to my client. We shouldn't have to be told that our legal rights on which $2.9 million turn should depend upon selective experts, which may or may not support Mr. Berry's inference. But if they do, they're relied upon acontextually and more fundamentally without the primary evidence that there would have been had this point properly been taken. And we say that really is it, if you accept that there is evidence out there that is not before you, that is it. You should not go any further. We do say in any event that Mr. Berry's submissions proceed on false assumptions, unsafe assumptions. I've already pointed out that no attempt is made to compare and evidence the overall financial position in the breach and the no breach world. Essentially, it's simply assumed that the only difference is the absence of the roll swap and an external hedge in the counterfactual world. It's simply assumed that that's the case. Who knows? Who knows whether that is right? It seems unlikely. As I've already said, we don't know at all anything about external hedges in the breach world. It's also premised on the basis that unidentified physical trades, which are the source of the offsetting paper swaps held by the judge in the breach world, to have offset internally the paper risks derived from the TOTSA contract, would not have been offset in the counterfactual world.
Sorry, can you just
sorry, that was a very long, confusing proposition. Let me try that again. Mr. Berry's argument is premised on the basis that the physical trades, which are the source of the paper swaps that were held by the judge in the breach world, to offset the paper risks derived from the TOTSA contract as rolled,
to offset, I'm sorry.
Sorry, excuse me.
You said to offset the
paper risks derived from the TOTSA contract as rolled.
Yeah.
I'll finish the sentence and then perhaps just break it down into something more digestible. It rests on the premise that those risks in the counterfactual world would not have been offset and therefore would have been directly hedged externally. And so let me just unpackage that so there's no confusion. This is an important point. So in the breach world, what Mr. Burt decided was that the paper risks derived from the TOTSA contract, as rolled because of the delay, were offset. They found a match with another set of paper risks. That's the breach world. So what Mr. Berry's argument is, in the counterfactual world, the paper risks associated with the delay to the TOTSA contract would not exist, because there would be no breach. So his argument is that I can use that risk I've just referred to as X and the offsetting risk as Y. In the breach world, X offsets Y. But in the counterfactual, there is no X to offset Y. And what Mr. Berry says is, therefore it's not offset. Therefore it must be hedged. That is the essential basis of his case before you. But it proceeds on a false basis. And the false basis is that in the counterfactual world, there may well have been, we simply don't know because it was not investigated at trial because it wasn't relevant, other transactions which could offset against that risk. No possible basis upon which he can ask you to find today that in Vista, at that time, there was no other risk that could have been used to offset that risk, whether in part or in whole. It's a matter of evidence that we do not have. And moreover, what we do know, from what I showed you from Mr. Smith earlier on in paragraph 43, is that it would only be once the process had been completed, i.e. of looking through the book more generally, that any external position would be considered. In other words, the clock doesn't stop at the point that Mr. Berry suggests it does. Just because in 101 you might have had an imbalance because the rolled pricing risks were no longer there, doesn't mean that you keep looking. So it doesn't mean that you don't keep looking.
So you said fallacy is to take page 32 in isolation and not then go on to look and see across the whole book.
Absolutely. So just to be clear, page 32 was the evidence about the breach world.
Yes, yes.
But as I showed you before, that there was no real investigation in the breach world what happened next, because
Yes.
as I showed you, that wasn't part of the appellant's case. But the same is true in the counterfactual world. We know nothing about the counterfactual world. The only thing we start with is the premise that the TOTSA roll swaps don't exist because there's no voyage. That's all we know about the counterfactual world. We know nothing else. It would have been, as I say, an exercise in reconstructing the book. But it would be wrong to simply assume that there wouldn't be other transactions out there. Just because I've managed to match 2, there might have been 3 others that I could have matched against. Who knows? The case also has now presented, as I've already referred to, also proceeds on the basis that if a risk had not been internally offset, it would have been externally booked. It would have been externally hedged. And I've already shown you, at the risk of repeating perhaps for the second time now, shown you paragraphs, I think 141 to 143, where the case was argued at trial on the basis that it was possible that speculation would occur. So whether in fact it would have occurred in the counterfactual world would have been a matter for evidence at trial, if this point had been taken. And just as perhaps a more minor point of detail here, in that context, it's worth bearing in mind that when the swaps were originally booked, the pricing dates were some 36, 37 days away. So the swaps were booked on the 30th of March to deal with a pricing risk starting on the 7th of May. So quite a significant interval. When we get to the...
Say swaps, there was only one at that stage, wasn't there?
Only one. So one can see in the course of ordinary practice why VITOL would not speculate on that risk. It's a significant period of time. But when we come to the counterfactual world, it's a different world, because we know from Mr. Smith's evidence that the internal swap was first rolled on the 4th of March in respect of only a quantity, so about 185,000 barrels. So
4th May.
4th May. So on the 4th May, we're now rolling for about 10 days, 12 days in front. So that would be highly material, we say, to any case that may have been put at trial about, oh, you'd definitely externally hedge, because then the trader has got a much clearer sense for what the market's doing. And indeed, Mr. Berry's case is that they would have concluded a 3 million loss-making hedge in respect of a pricing risk that was about to lock in about 9 days' time. That would not be the performance of a very good trader, one might speculate. Now, I don't need to make good that argument, but it's simply a way of exemplifying how important the facts are for this case. You can't simply say, oh, over here it says that you've got to hedge wherever possible, therefore they would have inevitably have hedged. You need to know what the risk would have been, and we don't even know that. I'll come back to that. So we say even if the argument is open to Mr. Berry, it's premised on those assumptions which are unsound, and again, had the point been taken, we would have had that evidence, but for better or ill, we would have had it. So just developing in a little bit more detail and supporting it with some reference to some of the materials for what it's worth. I just wanted to kind of pick up on the last point I just made. At various points in his submissions, which reflects what he said in writing, Mr. Berry was using language of his best estimate of what would happen financially was 2.89. Could be higher, could be lower. Probably an external hedge would have been booked. In writing, he says and concedes that the precise terms of that hedge and that loss were impossible to assess precisely. Now, let's be clear. If there had been an investigation at trial, it would not have been impossible to assess what external hedge, if any, would have been concluded. The court would have had the evidence, it would have applied the balance of probabilities, and it would have established what the position is. And this isn't a minor trifling point. As I've said, $2.9 million turns on this, and what my learned friend is trying to do is to reduce the admitted $3.7 million loss I've suffered on the Topsa contract by reason of an actual benefit that he says would have existed in the counterfactual world. So he can't come to this court now and say it might be 2.8, could be 2.5, could be 2.6. What would have had to be established at trial is precisely what would have happened. And who knows what might have been. As I said, one possibility is that nothing might have happened. The risk may have been sufficiently clear that people were prepared to write.
Have we got a figure anywhere for VITOL's daily turnover?
I don't know.
We made it somewhere in some of the press articles.
But there may be something in probably out-of-date press articles, but certainly it wasn't the subject matter of any evidence.
But yeah, that's a point that might help you. Because, again, it's an area of speculation.
Yes.
Because I think what Mr. Berry says is you can assume that the swap instrument is a valid proxy for the avoided hedge, because the whole point of the VISTA system as a whole was to ensure that even if it went through the crunching, it identified the same level of pricing risk. But that seems to assume that it did so with 100% infallibility, which I thought that was VITOL's view about it. They may have thought it approximates to within, let's say, 1% of our turnover or 0.5% of our turnover, and that's good enough for managing our risk. We can't get the algorithms to be perfect. But I'm just interested in how 3 million compares as a percentage of annual of daily turnover.
One moment, I think I've just been.
On the relevant product, oil, physical oil. Or are we including their other business?
I've been directed to do something in the supplemental bundle which doesn't give you a number but gives you a sense of volume, if that assists. It's 202 in the supplemental. It is tab 17. It's the penultimate paragraph, looking at the position in 2021.
Is that 7.6 million?
So 7.6 million barrels per day of oil and petroleum products in 2021.
Sorry, which page are we on?
It's page 202 in the supplemental tab 17.
But which paragraph?
Penultimate.
Penultimate, thank you. Oh, yes.
There's also a reference, I think, at the top to profit, net profit, 4 billion. Reported to the anyway. But my lord, if I could just pick up on something that was put to me by my lord Justice Popplewell. Whilst Mr. Ferry says it's a proxy, the point I've tried to demonstrate in the debate is that that's a fallacy.
I understand.
And to be clear, and it may come in at the res inter alias stage, is that what Vista is doing, is not doing, is trying to replicate one-to-one external hedging. It's not doing that. It's trying to get to a position where it knows at the end of the internal processes where its overall position is. And that may matter to res inter alias actor because when we come to look at the judge's analysis of res inter alias actor, at least in the context of a slightly different issue before him, it seems to me at least that he was referring in terms of external hedges counting to a one-to-one external hedge rather than external book hedge, which as I've already explained and come back to is it's the effect of it is the consequence of all the ingredients which form part of it. It's not possible to say that one particular gain or loss can be pointed to a particular trade.
And you say he approached that because the way it was argued was either you just look at 645's position, or if you don't, the res inter alias actor point arises if you treat 101 as separate, but don't go any further.
Absolutely. But that was what was before him. Absolutely right. So in that sense, and that was the argument, it was said that those internal hedges were external, effectively one-to-one hedges in effect. But what we're talking about now is a different beast. We're talking about either, and it's unclear, an external hedge in respect of some identifiable transactions or a book hedge. So we say the fact that Mr. Berry can only speculate as to precisely what hedge may or may not have been considered. We don't know in respect of what physical product. We don't know anything about its terms, its pricing, its origin. We know nothing. So if I can then just quickly please show you some parts of the Crane case which we say are highly material to our situation. We can pick that up. I think some of them have it loose. So they're points of principle. But for what it's worth, we'd say our facts are stronger still, but that doesn't matter. It's the points of principle. And I'd like to pick up these at para 18. So para 18 starts in the third line. An application to amend a notice of appeal raises special considerations which do not apply to an application to amend a pleading prior to trial. In the case of a pleading, the court will readily give permission to amend so that the real dispute between the parties can be adjudicated. But on appeal, the position is different. The simple fact is that there has already been a trial.
So I'm not found where you are.
Apologies, my lord. I'm at paragraph 18 of Crane,
18,
under conclusions. And the point I was bringing your attention to is the observations of Lady Justice Arden that an application to amend a notice of appeal is different from an application to amend a pleading. The simple fact is there had already been a trial. The significance of that is that the parties would have had an opportunity to put forward their cases and incurred costs. There will have been a decision. And just pausing there, we'd say that that reasoning applies with equal effect to a skeleton argument, for which the Commission has sought to introduce a new case. even if it was said that technically the notice to amend wasn't required by reference to the grounds of appeal, plainly the skeleton, we say, attracts the same issues. If you could then please read to yourself paragraph 52 of Jones and MBNA, which she then cites. We say all applicable here, particularly bringing attention to a party cannot, in my judgment, seek to appeal a trial from the basic claim which could have been before, was not, would have succeeded if it had been so brought. And then, similar vein, para 19, quoting from a speech of Lord Herschel in Tasmania. In the first paragraph, a new point must be most jealously scrutinised. Conduct of the cause that the trial is governed by, and the questions asked of the witnesses are directed to the points then suggested. It is obvious that no care is exercised in the elucidation of facts not material to them. So that's a clear reason why you should be careful about relying upon evidence that's used to meet a different case of trial. And then ought only to decide in favour of an appellant on the ground there put forward for the first time, if it be satisfied beyond doubt, first, that it has before it all the facts bearing upon the new contention, as completely as would have been the case if the controversy had arisen at the trial, and next, that no satisfactory explanation could have been offered by those whose conduct is impugned if an opportunity for explanation had been afforded them. The second point doesn't really apply quite directly in this case, but the first point certainly does. You have to be satisfied today, beyond doubt, that you have before you all the facts bearing upon the new contention as completely as would have been the case if the controversy had arisen at trial. And there is only one answer to that explain. I'm not going to use more judicial time going through this judgment. I would simply re-invite you, if you haven't already, to read the paragraphs that run down to 26. We did direct your attention to that in correspondence. My submissions rest entirely on the principles that arise there, and we say this is a paradigm case that falls within those principles. So we say, therefore, the point isn't open, it shouldn't be considered, the court doesn't need to wrestle with it. But if you're against me on that, then I now just make some submissions which I've already trailed as to why the necessary inferences can't be derived even from the limited evidence that you have before you. And I wanted to focus on the contention that there would be no other available offset for the risk which Mr. Berry says would have been externally hedged. And
sorry, could you just take a bit more slowly?
Apologies.
No other available offset.
I'm going to focus on the argument that Mr. Berry says that there would have been no other available offset for the risk which he says would have been externally hedged. And then the question of speculation. So could we first, just dealing with the first question, just go back please into the judgment at page 88, which we looked at earlier on.
Sorry, which paragraph did you say?
Sorry, I haven't given you a paragraph yet. Paragraph 142. You can pick it up at 144. So at 144, the judge was obviously dealing in the breach world with what would have happened with the pricing risk derived from the TOTSA contract as rolled. And the judge said at 144, I accept that the likely positions that risk transferred into 103.8101 by the rolling swaps was offset within the VISTA system by opposite risk, which ultimately originated with other physical trades. Now, just pausing there, the judge does not make any findings as to what those opposite risks were. He doesn't make any findings as to where in the VISTA system they would have been found. And therefore, at what stage in the risk management process the offsetting would have occurred. And that, we say, is important because you would need to know that for the purposes of the counterfactual inquiry. Now, as I've said, the submission here rests on the premise that there would have been no other offsetting risks available to be found in this in the counterfactual world. Could we look at these earlier on in the judgment at page 64? Paragraph 48. So here the judge, based on the evidence, is giving a rather longer description of how VISTA works than I have done. And if we could pick it up at 49, please, page 65. So talking about internal processes first done within a given subdivision, and then that subdivision's exposure is offset against other subdivisions in order to manage and pool risk efficiently across VITOL. So what's being made clear there is that the offsetting exercise, if I can put it in those terms, is being made at multiple levels. It's not simply done in one portfolio. It's not simply done in 101. It's done across the books. And if I could then show you a slightly longer description of that by Mr. Smith in his evidence, please. Sorry, I apologise. In supplemental, if I could go to the first tab, please. And we could take it up at page 3, paragraph 15.
Yes,
So
sorry.
Mr. Smith's statement at the bottom of 3, he explains that the trading structure of VITOL's group can be described as several separate thoughtful legal entities, which each have a series of trading divisions. Those trading divisions in turn contain portfolios, which are further split into subdivisions. Individual sale, purchase-related transactions are grouped together within those subdivisions, and then gives an example about portfolio and subdivision with which the TOTSA contract is concerned. And then if we could jump to page 5, please, B, which is paragraph 19B.
So sorry, where have we gone?
We're still in Mr. Smith's at page 5, please, at paragraph 19B.
Yep.
So here he's talking about the process within VISTA. So after you've included in VISTA the physical transactions and the initial paper hedges, says that the counterpart portfolio to each of those paper hedges will contain other unrelated paper hedges arising out of other VITOL transactions. Thus, in the counterpart portfolio, the risks from each of those other transactions are grouped together with the other trades within a single subdivision to allow my team to view the net risk exposure of that subdivision. It then carries on over the page. And perhaps if you could just read C to F to yourself, please. And then 20 as well, thank you. So those paragraphs are what reflects the slightly more abbreviated description for the judge in his judgment. And then, if I could show you that, for what it's worth, that Mr. Beckett, the appellant's expert, had no dissent from the proposition that that's how, as it were, the search for offsetting transactions would occur. So that's also in the supplemental bundle, tab 12 at 165, page 165, please.
So is he saying that you don't do it for VITOL as a whole? You do it trading division by trading division, and that's as far as the consolidation gets?
I don't understand that piece of evidence.
He starts by saying each of the corporate entries will have a series of trading divisions, and the relevant one here at the beginning of 16 is the crude oil trading division, and then that's broken down by portfolios and subdivisions.
Yes.
When we get to the para 19, which is the
Yes.
exercise of trying to identify the overall risk exposure of the relevant VITOL corporate
Yes.
entity. It doesn't seem to go beyond each division.
Indeed, my lord, I recognise up until that last sentence and what's then said in E, it might be thought that he's talking about grouping being done at a trading division level in that layered way, as it were, rather than across the corporate entity. But
It's not clear.
it's not clear that D and E might suggest the latter. But we would say in any event, the submission still stands. The search for an offset is not limited to a single portfolio. So the fact that in the counterfactual world there wouldn't have been a matching offset in 101 does not mean there would not have been a matching one elsewhere in VITOL, and a search would have had to have been done for that. And I just, if I could, show you Mrs. Beckett on that, please, at 165, tab 12 in the same bundle. Page 3 of 8.
So page 165, paragraph 3.18.
Yes, that's right. Thanks.
Sorry.
No. So there is, as it were, Mr. Beckett's own understanding of the search for an offset, referring to allocations. So this is 4 lines from the bottom. These allocations might be to other match deals within the many subdivisions of various portfolios, or moved into a speculative or derivative portfolio, where they can be packaged and resold, or the risk transformed by combining with other derivatives. So again, evidence on the appellant side, as it were, that you would have to look in lots of other places before you could conclude that a single risk is not offset. And also in this context, before we get to speculation, quite clear evidence from Mr. Beckett that he would understand that risks derived through this process of VISTA may well end up in a speculative or derivative portfolio.
Again, he seems to assume that consolidation is only up to a division level. So references in 3.18 as a crude division level, and his little chart at 161 to what's happening within crude.
Well, let me show you some more evidence on that, my lord. He seemed to go wider than that. If I can just find a reference. Yes. Same bundle, please. Tab 20, page 246. So 246, page 45 of the transcript. I was asking a somewhat narrow question of him at line 13. I think he may have said earlier on, internally offset against other internal swaps derived from West African chain trades.
So which paragraph?
Sorry.
So which page? 45.
Line 13.
Line 13.
So this is about discussing where the paper risks derived from the TOTSA contract may have been offset. In the breach world, of course, you may have said earlier on internally offset against other internal swaps derived from West African trade, so it could have been internally offset within 101. Is that your view? That could have happened. Could have been, I wouldn't limit it to West African swaps. I think Mr. Smith says that once that book has been looked at, then they look outside of that, to which I said correct. And then he talked about it could be likely to offset with some North Sea trades or other dated trades on the crude book, even on the gasoline book. There would potentially be dated Brent trades.
So even you could consolidate with the gasoline,
yes,
not just the crude book.
Correct. So, and so it continues. So that evidence, and I'm not, but you understand, I'm not trying to take evidence out of context. I'm not the one saying that you should make any findings in this regard. I'm the one that's simply saying when you're being invited to make inferences from evidence given other than directed to the question before you now, you need to see what other evidence there is. Because you've got to make an inevitable inference. That's what's being asked. So, quite clear, we say, had this been run at trial, we would have had to have investigated all of the book to try to see whether another offset could have been found. And if it had, there wouldn't have been an external hedge in the way that Mr. Berry says there is. Now, as for speculation, really I don't need to go beyond, I would suggest, what I've already shown you in the judgment, that it is possible, and it was put that way at trial by the appellant, it was possible that there would be speculation of these types of risks. But I will just show you, in the interest of balance to what Mr. Berry has shown you, one or two other bits of the evidence which mitigate, militate, against his imputation that it's inevitable that if there had been an unoffset risk, it would have been externally hedged. That's what he invites you to find. So again, in the supplemental bundle, please, this time at tab 3, page 57. Page 561 here, because this is a paragraph of the evidence that Mr. Berry relies upon in support of his position in his supplemental, where he says the submission is at paragraph 12a. The very decision to roll the swaps and offset them against the opposite risk demonstrates that VITOL would hedge both sides of the risk. And he relies upon this paragraph of Mr. Beckett's evidence in support of that submission that they would hedge both sides of the risk. And I wanted to show you 5.61 because that's not what he says. He says that if there was no internal match, VITOL would have looked, and only then would they have looked at hedging externally. By the same logic, if the other side of the match within the VITOL group had not had this deal to match against, they too would have to consider covering in the external market. So he makes the same logical fallacy that Mr. Berry makes as well. But all he's saying is they have to consider the position. He's not saying they would never have speculated. If we could, in a similar vein, go to tab 11, we were shown this by Mr. Berry. Page 151. And this was shown, it's the point of agreement with some differences. Point 14 at the top of 151. And you were shown this in support of the perceived distinction between different types of risks that could give rise to entering into these speculative derivatives. But what one sees here, this is Ms. Bosley's view in the final 6 sentences, is that the approach allows them to get in and out of positions quickly if they change their mind. But the whole point of consolidated centralised risk management is that hundreds of disparate risks, whether from vista hedges or not, can be considered in the round and used to inform the entity that is considering taking a speculative position on whether it is overall long or short of a particular position. using and managing the risk of VISTA hedges. So it's quite clear that what Ms. Bosley is talking about is the VISTA is feeding into the position taken externally and whether to speculate or not. So I could give you many more references, but I don't need to because the judge accepted that it was possible that these types of risks would be speculated on. And that is the burden of the evidence that is before the court, albeit not directed to the question with which we're concerned. Now, we say therefore that the landing point is that even if you consider the arguments open to Mr. Berry, he can't prove inevitably what would have happened, that an external hedge of any kind would have been concluded, what its terms would have been, what its effect would have been. You can't prove that it wouldn't have been internally offset. But if you're against me on that, one's left with the question of, well, where are we then? And what he says is that one ends up with an external hedge in a counterfactual world, which, and it's a curious feature of this case, is not an external hedge that, when hypothetically speaking, was created, had anything to do with the TOTSA contract at all. Because what he says is that risks derived from other unidentified physical trades would, in a counterfactual world, have been externally hedged. So, in the context of a physical claim for loss and damage sustained on the TOTSA contract, it is, we suggest, not a hugely promising start, that what he seeks to bring into account is the absence of an external hedge in respect of some other trade altogether. That hypothetical trade plainly has nothing at all to do with breach.
This is a raising jury.
This is the raising jury. Sorry, I should have signposted where I was with this section. So just to be clear where I am, because I didn't do that. I've gone through pretty quickly why I say the factual basis for Ms. Berry's submissions are unsafe, and therefore you cannot conclude that an external hedge would have been concluded. And now addressing the point, if you were to get to the position that you felt that you could and should make that decision, and what I'm submitting is that in that situation, the avoidance of that loss on that hedge would be res inter alias acta. And my first point is that it's an odd starting point for a defendant to a claim for breach of contract to seek to rely upon the non-making of a instrument designed to protect pricing risk with a contract which has absolutely nothing at all to do with the contract pursuant to which my client makes its claim. At the time at which this hypothetical hedge would be concluded, there would be no conceivable basis upon which anyone could identify any connection between that hedge and the TOTS contract. So what would that hedge, what would be the raison d'etre for that hedge? What would be its reason? Well, the reason for that hedge would be to protect pricing risks arising out of a whole series of transactions which VITOL happened to have on its books. And happened to have on its books independently of the TOTSA contract and independently of any breach. So we would further say, by its very nature, which is the type of hedge which one cannot connect sensibly with any particular contract at all. It's the function of the recipe, which I talked about earlier on, where you put all the risks into a bag, shake it all up, and what you end up with is a net exposure which may then be hedged. So we say not a promising start at all, because of the lack of connection. And we accept entirely what my Lord Mrs. Popplewell said, that factual causation is insufficient. The the Fulton case is not before you. Part of an explanation maybe for that, but we were already down that this is a case of avoided loss rather than mitigation, albeit we recognise that the principles are not dissimilar. But plainly that case is an example of why factual causation is insufficient. And we say this is another one, because ultimately what Mr. Berry says is, well, in the counterfactual world, the reason's entirely unconnected with me. You've got an external hedge that's made a loss, which has been concluded to protect pricing risk, nothing to do with the TOTS contract at all. But in the breach world, it has got something to do with this, but not the hedge. The hedge has nothing to do with TOTS or in the breach contract. It's the risks which contribute to the net exposure that leads to the external hedge, which have something to do with TOTS in the breach world. Namely, they're internally offset against each other. But when one reminds oneself that what Vista is doing is offsetting risks not for the purpose of avoiding any loss on any particular contract, but as a means of seeking to identify the net exposure at that time of all the books. That connection in the breach world is also legally irrelevant. It's entirely happenstance that two particular risks may be offset against each other, as opposed to as offset against other risks. So we say there is no relevant sufficient legal connection between the mere fact of breach and the avoidance of an external hedge in respect of completely different risks altogether. And could I show you, please, some evidence recorded in the judgment at page 65? Again, I recognise in a different context. Paragraph 51. So this is.
Sorry, I've got confused. Paragraph 51.
Page 65, paragraph 51.
Yes, sorry.
So this is the judge continuing on from his explanation of the VISTA system, and then saying this set of internal processes allows VITOL to understand its overall exposure to the relevant risks. To the extent that VITOL is long or short on a net basis, any particular position across its portfolio may choose to use external hedges, or it may choose to maintain that market position, so that's the speculation again. If the decision is made to take an external position with a third party, that will be entered in VISTA and allocated either to a specified defined group of transactions or a generic pooling of risk. Mr. Smith explained that an external hedge is only allocated to a specifically defined group of transactions if it is requested and required by the relevant broker. Otherwise, it is grouped across the portfolio and arbitrarily allocated to external trades. This was a process Mr. Smith described as a book hedge, being where a trading house hedges the aggregate position of its book of trades from time to time, rather than by entering into individual hedges for each trade in its book. So that is a description not of the book hedge with which we're hypothetically concerned, but book hedging generally. And the same point applies here. VITOL would not have booked a book hedge against specific transactions unless asked to do so. And the reason that it would not do so is because the hedge represents a position taken on a large number of transactions which contribute to establishing the net exposure. So any external book hedge, by necessity, cannot be connected to any particular trade. So we say, in effect, both sides of the analysis here are res inter alias acta and or causally irrelevant. In the breach world, as I say, the matching is not done for the purpose of avoiding loss. It's done for the purposes of establishing overall net risk. And on the counterfactual world, the loss on that hedge cannot be ascribed to the contracts, the pricing risks of which would, in the breach world, have offset the toxic contract. So you can't take the loss on that, apply it to those risks, and then apply it to the physical loss that my client has in fact suffered. Unless there are any questions, I didn't propose to ask any more.
Yeah, thank you very much, Mr. Toms. Yes, Mr. Derrick.
The first issue is whether the argument should be allowed or not. And I've already made my submissions about it being within the pleadings and within the notice of appeal as properly construed. And by reference to the Crane case, the report of the Paramount case in that respect. So my learned friend suggested things would have gone differently at trial, but he only made one concrete suggestion. And that concrete suggestion was that my predecessor should have put it to the witness, so what would you have done? Would you have externally hedged? And the answer would have been, the answer that he was given, which is that's not my decision, that's for somebody higher up than me, who they didn't call, and they didn't call at the time when they were deciding who to call on the pleadings, which admitted this point. The second suggestion is that other documents or other evidence would have been required. And again, if one retrojects back to the trial, to the time of the trial, what other evidence? Again, there was one only concrete suggestion, and that was that you would have to reconstitute Vista and examine the Vista work product, which is the net risk at the end of the day once Vista has done its crunching. And in my submission, you would not have to do that at all, because you would simply have to draw conclusions from the fact that this particular risk, that is to say the 7-day risk of a price rise, was in fact matched by the commercial analyst within Vista. And the result of that is to change the net exposure of VITOL. No, it isn't, sorry. The result of my client's breach is to change the net exposure of VITOL by 920,000 barrels over 7 days. And that is a change that necessarily feeds through Vista, that necessarily changes the answer that Vista gives you at the end of the day as to the net exposure. And it doesn't matter whether there is an external book hedge already or not, because if there was one already, here is 920,000 barrels that would have to be added to it in order to comply with the hedging policy. And if there is none, then one would have to enter an external hedge to comply with the hedging policy. So when one puts together the purpose of Vista, identify net risk, with the policy, subject to speculation, hedge against it, it follows that my client's breach contributed 920,000 barrels worth of risk for another 7 days, which Vista would necessarily identify as upping that risk. And Vista has already done the job before it produces that number of matching everything that can be matched. So ex hypothesi, there cannot be another matchable risk in the portfolio. Adding that 900,000 barrels of oil, therefore, must, in Vista, have an effect on the bottom line, which goes to the making of an external hedge, in which I include the increase of an external hedge by that by that amount. So it really does not matter. You do not need to recreate everything. It follows from the findings that the judge made. That question, these questions overlap. The next question is whether I can, whether on the facts I can establish the avoided external hedge. And I submit that the test here is not whether it is inevitable that that was the case, but if you accept my first submissions, that actually there has not been identified any different event at trial or any different evidence that could have been adduced at trial starting from day one, then the question is back down to the balance of probabilities. So if the issue is admitted, it is a question of balance of probabilities, provided you accept that no credible or useful evidence could have been got that could affect the question, which is my submission. And it is the balance of probabilities. But I do say on the facts, though unnecessarily, that it is an inevitable result of the VISTA system that it produces a total number at the end of the day. And if you take out of that system 920,000 barrels, then that must inevitably have an effect on the result, and the result will be an increase in the risk. You then have speculation, and in my submission I've put in all the references to speculation. Speculation is unlikely as a balance of probabilities. It's against the policy, it's the non-default position, and I submit it wouldn't happen. I submit on the balance of probabilities it wouldn't have happened, but I say the inevitable inference from their policy is that it wouldn't have happened. And finally, as to res inter alios acta, my learned friend says that it would only not be res inter alios acta if you could tie the external hedge to a particular transaction. And we contest that. And that would make this issue, res inter alios acta, depend on whether or not within VITOL they took the positive decision to make the link or not. But that is a positive decision within VITOL that makes no difference to anything. So if, on the hypothesis, some trader within VITOL said, actually, I want part of that or that external hedge to be related to this, they would say, fine, then it's not res inter alios acta. But if the only consequence is that my client's breach has changed the risk, which has changed the amount that needs to be internally hedged or created the need for an external hedge, then that wouldn't be caused. And this is a point of some possible general implication. If a defendant's breach increases the exposure by 900,000 barrels, that increases the hedging need of somebody in the position of VITOL, and they hedge for 900,000 barrels more than they would otherwise have done. But they don't actually say that the size of the hedge actually taken out is in part attributable to this one risk, then it is res inter alios acta. But if they do, then it's not res inter alios acta. That can't be right. The causation...
The second half of that may not be right.
Yeah.
Just because if it's not capable of because it's a book hedge of sensibly being treated as a matter of law as allocable to any particular 920,000 barrels of which they're short or long, then just because they choose for internal purposes to put it in one portfolio or another doesn't affect the legal position.
Yes, that's my submission. But on my
but your submission was, if they do, in those circumstances, if they do choose to allocate it to 564, you're assuming that that stops being res inter alios acta.
I'm parodying.
I'm cavilling at that.
You're agreeing with me, my lord, because I was parodying my learned friend's submission. My learned friend's submission was because we can't tie it to 564, therefore it is res inter alios acta. Can't be right. The wider question, because that would make it depend on the internal decision whether they chose to allocate it.
No, whether they allocate it internally or not. It isn't as a matter of law allocable to any individual risk.
Is the question of law that arises.
That's the question of law, but your point is, I've got them, because they accept if it was allocated to 564, they couldn't run the res inter alios acta point, and I'm pushing back. I don't think it's what they're saying, and I'm not sure if they were right.
Well, I read it down as it was impossible to ascribe it to a particular transaction, and therefore, but if that's not what he meant, that leads us to the question of law, which is this. Let's simplify the numbers completely, and this is actually what the VISTA system does, but extraordinarily simplified. It's another thought exercise. let's take two slightly examples. Let's say that the Vista system throws up at the end of the day when these decisions are made or whenever they're made, that we are 10 million barrels, let's say 1 million barrels, exposed to a price risk. And that is made up of 10 separate ships, 10 separate physical trades with their attendant paper things. So we are exposed to the tune of 10 million. And then during the day, my client breaks the contract, which creates another 1 million or 920,000 barrels of risk. The exposure is now 11, but virtually 11 million, I think, yeah. The trader, so not the trader, the risk analyst goes out to the market and says, I have to hedge 11 million. It has gone up from 10 to 11 because of the breach. But because it's a book hedge, can it really be said, well, is it said, well, the question is it right to say that that bump up from 10 to 11 million on the need for external hedging was not caused by the breach that moved it from 10 to 11?
Well, that's fine if he does it the same day and he was about to do 10 and he suddenly does 11. Well, that's not how the system works. What in fact he does is 136 or 14 or any other number, which is the product of a whole series of different trades on which there may be breaches not just by your clients, but a whole lot of other clients or transactions. So you can't attribute any particular amount to any particular breach, can you?
I submit you can attribute the increase to any of the breaches that caused the increase. Certainly in a but-for way, because if I hadn't broke my contract, their need would still be only to hedge 10 million. And because they hedge on a book basis, why should that, for prudent reasons, why should that make all the difference between a much smaller trader who has to hedge on an individual basis and he can't aggregate the risks so that they lose their identity? But in his case, he has to give back his hedging profit because you could say, oh, well, I know for a fact that this, or he can add his hedging loss depending on which way it goes. But let's say he has to deduct his hedging profit simply because I can trace it through this process. That is materially, in my submission, exactly the same, only less complicated than when a Vista system does it multiply. And the reason the Vista system comes up with the answer, it's 11 rather than 10. A proximate cause of that is the breach that caused it to go up from 10 to 11. And if it was an earlier breach that caused it to go up from 2 to 3, that would be the same answer as a matter of analysis. So you have two traders. You have a small trader. He doesn't have a Vista system. He's not VITOL. He does a hedge, which is imperfectly, makes him 2.6 out of 3 loss. He's done. He has to give that back. You have the great VITOL, who do what is functionally exactly the same thing by feeding that loss into VITOL, or that risk into VITOL. It churns out the answer at the, it churns out the answer at the end of the day. You're 11 instead of 10, or possibly you're 1 instead of 0. Doesn't matter. That's why it does not matter. We wouldn't have to go into the question of whether there were any external book hedges, because if there weren't, then there would have to be one, and if there were, then there'd have to be 920,000 barrels more.
What happens if it means you're naught rather than -1?
It's exactly the same point, because then you.
If you're naught, you don't hedge. You don't
quite,
hedge at all, so there isn't a hedge to be avoided.
Quite. You're only naught because of the breach. If it wasn't for the breach, you'd be -1. You'd have to enter hedge the other way. So it must. When one thinks about it logically, it must be so. It must be so on a system like this, which is designed to avoid speculation, the insertion or the extraction of a 900,000 barrel price risk. And this is why I come right back to the beginning, what Mr. Young did argue. There's no difference between an internal and an external when it is accompanied by a system of this nature that has a Vista system that produces the number you have to hedge or decide to speculate on, it must follow that if when my client broke the contract and created an extra 7-day risk on the 920,000 barrels, it must follow that that moved the needle by exactly that much on the end result of Vista. And that is why I say one doesn't have to look into the detail, one doesn't have to know how it does it, one doesn't have to know whether it takes into account gasoline, fuel oil, naphtha. Doesn't matter. Vista does that.
You have to assume it does it perfectly to the very dollar.
No, I don't. I don't, because we know it doesn't, because on this occasion they were $800,000 out. All I have to assume is that the margin for error when externally hedging instead of the externally hedging would have been about the same. I positively assert that they're not going to get it to the exit. That's what they're aiming for. But they will never do that in real life because, of course, Brent is only a proxy inexact for West African crude, etc., etc., etc.
No, I'm not sure I follow that. The notional hedge we're talking about would be the opposite side of fixed for floating. So that it doesn't matter what the floating price turns out to be, as it happens on this, it gave rise, you would have had exactly an oppositional risk. Isn't that right?
Well, no.
I misunderstood.
Not necessarily, because the floating price of the Brent might be different from the actual price of the West Africa. I may be addressing a completely different point.
No, I'm just, and it may well be my fault at this time of the afternoon, but you say the result of the rollover hedge was not to remove any risk, because it only generated 2.6 million, but it completely removed the risk of the movement in the prices over those days, didn't it?
I don't think it can have done, because the calculation of the increase in the price over those days was 3.6 million, and the calculation of the notional benefit from the hedge to 645.
Sorry, what I meant to
2.8.
say is, if you had had a notional put hedge against that, to match it.
Yeah, it would have been the same as the 2.8, yes.
Yeah, so your notional hedge would have produced net zero. That's what you're saying.
My primary submission is the notional hedge would have produced exactly the same result as the hypothetical internal hedge, except for transaction costs.
Right. So what you are saying, I think, is that you have to assume that Vista, if it had identified that, what you put in simple terms, 10 million or 11 million risk, and you'd taken out your hedge, that would act perfectly.
No.
Although it would have to use a proxy, once you've got your oppositional hedge, which you've avoided doing, that'll wipe it out completely exactly.
No, I think, well, I may be myself suffering from cognitive something or other, but I think what I'm saying is that the hedging is necessarily imperfect, unless you get the exact same cargo on the exact same date and the exact same product. Hedging is necessarily imperfect. The imperfection of the internal hedge was to the tune of $800,000. What I'm saying is the imperfection of the avoided external hedge should be assumed to be as imperfect as the internal hedge. Not perfect to the dollar. They wouldn't exactly bridge the difference between 10 and 11. It would have been no more imperfect than what they did enter into the system. And therefore, to hedge a price rise risk of 3.6 million, the actual imperfect internal hedge, which doesn't involve any transfer of money in or out of VITOL, only produce a benefit of 2.88. But had they gone out at the time, made that decision on the 4th, we've got to take an external hedge because this has pushed the needle up to 11 or 10 or 0 to 1 or minus 1 to 0, doesn't matter. Any of those are all exactly the same in principle. They would have gone for an external hedge. They would have tried to hedge 920,000 barrel price rise for 7 days, and because of the imperfections of the market, they would have not got it. They would have not got 3.6 bang on the nail.
But
there would have been no worse.
Down the rabbit hole. What I'm really getting at is if the nature of the hedge found not to be once it's at the book hedge level.
Yeah.
It is only if the Vista system, in converting your rolled hedge pricing risk into something which is expressed by reference to something different, it is only if the Vista system is perfect to the very dollar in those two pricing risks being calculated in an identical way. If you're to take an example, if by the time you've consolidated risk, you're not doing it by reference, your book hedge is not by reference to dated Brent. It is in fact by reference to Brent futures, because you've put Brent futures in, you've put West Texas Intermediate in, you've put dated Brent, and anyway you're going to do it in relation to different dates. But that's your system has told you, this is your point, that that ought to have the same effect,
yes,
as if it's a rolled swap. And that's why you say, as I understand it, you can use whatever this instrument is, which may be different, as a proxy.
yes.
But I'm not sure I've understood why I'm wrong in saying that depends upon Vista, with all its various algorithms, being a perfect system in terms of turning risk on those 5 dated Brent days into the same as the risk on the derivatives that you in fact take out as the hedge which you say you've avoided.
I'm not saying it's perfect. I'm saying its imperfections can be assumed to be as imperfect as whatever mechanism you would use to go externally, because some similar mechanism of turning 920,000 barrels of West African crude hedged against Brent or WTI or something else, there would have to be a method there. Okay, it would be partly.
Well, you can hedge the trader can hedge the risk externally. If 564 had hedged it externally, then
and we wouldn't be here.
But equally, that's a perfect
Yeah.
a perfect reflection of the risk that we're talking about. But once it's turned into, let us say, by way of example, a derivative trade for dates in July on Brent futures, which the system says, when we've put everything together, is actually the same pricing risk as increased pricing risk we've been exposed to by reason of the rollover of those swaps. Then it's only if the system's exactly right about that you can use one as a proxy for the other.
Well, as an exact.
That's the point I've been trying to make.
As an exact proxy.
I
think I'm very slow. I think I do get it. So in other words, the figures in the Vista system for profit and loss are themselves likely to be wrong.
No. But the way you set them off will involve all sorts of subjective questions in the algorithms, which, although designed to be perfect, may not be. Maybe to a tolerance of 0.5%.
Well,
that's not good enough for you, with the sort of numbers we're dealing with in this case.
I submit it is, because if I'm 0.5% wrong, that is saved by the transaction costs that I'm not claiming. And so you can be sure.
No, but we're talking about 0.5% of VITOL's whole book.
Well, the contribution made by this to the VITOL whole book will either to be knock it off 0 or knock it at 900.
No, but suppose the Vista system is good enough to the nearest 0.5% of the whole book in terms of assessing risk.
Yes.
0.5% of VITOL's whole book is a huge amount, and if it is 0.5% out, you're not going to get the proxy.
But
are you?
I think you are, because so if Vista is slightly inaccurate in that it says, okay, let's take figures that actually make that more lively. Let's say that Vista says it's 100 million. You're 100 million light. You're exposed to the tune of 100 million to a fall in the market.
Yep.
And then there's a breach of contract, or earlier there's a breach of contract, which is now suddenly put in, and that takes you to 101 million. I think what your lordship is saying is that the Vista system, in saying that your hedging need is now 101 million, cannot be accurate.
They might be only accurate to 100
million.
Your whole submission depends upon the Vista system being as accurate as you would hope it would be intended.
I don't see that it does, because both on the internal side, that depends on the accuracy of the Vista system. And if they had, instead of doing it internally to go into the market, they would have to use the Vista system to decide how much they needed from the market. So the Vista system imperfections, small or large as they may be, are constant between the internal hedge, which they made, and the external hedge, which they avoided.
No, because the internal hedge was rolled over swaps.
Yeah, but it had to be priced.
We know exactly. We know exactly what loss that caused. That's your. But what we're looking at is whether that is the equivalent of the avoided book.
But those.
I think I've.
Yeah.
I've explored the point, but do say any more you want to say.
And Mr. Berry, you say Vista is the only measure that you've got.
Yes, and on both sides of the equation, I can see in my Lord Popplewell's point that small errors in Vista may lead to large numbers when hedging the whole book, but I can't see why that isn't the same both ways, on the internal and the external. I am being dense. I'm sorry.
Because the internal doesn't use Vista, doesn't go through the Vista system.
It does.
The internal is 564 to 101.
Yeah, but it does. But when calculating the price of the swaps on the 4th of March, it goes through. It must. Well,
that then feeds into the system.
Yeah.
But it's only once it gets into the system and comes out as an overall book risk that it's been subjected to the uncertainties in the algorithms that Vista apply.
Let's for the moment.
That's what I'm trying to say.
Let's for the moment forget the fact that it was a roll. Let's consider, for clarity's sake,
I agree.
a new hedge.
Doesn't depend on it.
Yeah, a new hedge, or a 7-day delay, which wasn't previously hedged before.
Let's just take the original swap.
Let's take the original swap. Well, it's the delay. Yeah, that is itself. Well, it's inputted into the Vista system, but the price of the swap must be gauged by the Vista system, because we're told that the Vista system churned out the result, including the pricing.
Yeah.
And if that swap had been avoided...
Well, sorry, the Vista system churned out the pricing for that.
Yeah.
That first level of match, because it used the market price, not because it was doing anything, not because Vista was doing anything with
Yes, it was doing the market, yeah.
Just doing the market. That's not what I'm talking about
I don't see
Vista doing anything.
I don't see how there can be a difference between that and an external going into the market to hedge for 920,000 barrels. So the Vista churns out a price and says, looking at the market price, this is the price you must pay for these swaps. If instead of doing that internal swap, Vista has said you're 920,000 barrels at risk of a rising price, go into the market and get it. I don't see what would be different there, because you'd have 920,000 barrels, you would crunch the market price in the same way that Vista did. The market might be slightly different from internal Vista, but Vista is representing the market. And then you pay some transaction costs. And the imperfections of Vista have no impact on the relation between the internal profit and the avoided external loss that I can see with my very non-mathematical brain.
I'm sorry, it's a bit late.
But that,
Thank you.
I'm sorry, that's so. I think I had. But Mr. Lack reiterates. I reiterate the point that it's a very odd and in our submission result that ought to be avoided. That if the oil trader, to 2 points, if the oil trader that had put this oil on our vessel had been a small trader who didn't have Vista, the profit calculated within the Vista system would come off, well, the profit that would be made would come off the damages claim. But because it's a big trader like this, and it has got a Vista system which merges everything up and takes the place of internal, replaces external with internal hedging, they're immune to the damages claim. Particularly as a ship owner, I mean, I'm not challenging the Heron tool, and I didn't get leave to appeal. We didn't get leave to appeal on remoteness, but particularly as the ship owner here has got no idea whether the trader inquiry, he might know whether he's big or not, one of the biggest in the world or not one of the biggest in the world, but he's got no idea whether he's got a VISTA system or not. And the result of this case says that the internal churnings of VISTA, turning a hedge from external into internal, makes all the difference between the normal position, which is hedging gain is deducted, and the abnormal position, which is that they don't have to deduct it.
As you acknowledged, that is a point you made earlier.
This is the point I made earlier.
Yes. Anything else, Mr. Well, we will be reserving our decision. Judgments will be circulated in the usual way for the purpose of the parties agreeing consequential orders, or if they can't agree, then providing short written submissions so that we can decide any consequential issues at the same time as hand down. Also, of course, for the purpose of correcting typographical or other small factual errors. And you will all be very familiar with the guidance given in the Counsel General for Wales case. Those associated purposes are the only reasons why any internal circulation is required, and they should not be circulated to anyone except for that purpose. Thank you very much for some interesting arguments, and thank you to those behind you as well as those who actually articulated them on their feet.